From the News Channel 5 Network, this is OpenLine.
Hello everyone, welcome to OpenLine. I am Ben Hall. Very good show tonight. Opportunity to learn about medical malpractice lawsuits. These are some of the most tragic lawsuits you can imagine, and also some of the most interesting. Many of us know someone who's had some sort of complication or some sort of issue. Does it rise to the level of a medical malpractice lawsuit? That's what we want to talk about tonight. We certainly want to hear from you. Happy to have with us Clint Kelly, attorney, medical malpractice attorney. Thank you for being here.
Sure, Pat.
So, what is a medical malpractice case? When you're hearing someone in your office say, "I think I have a real claim here," what are you looking for? What constitutes this?
A medical malpractice case is basically where there's been a medical mistake, and there are mistakes and then there are bad mistakes, and these are cases where there have been bad mistakes. Typically you have either a physician or a nurse, some other type of healthcare provider who has provided substandard care where other physicians or nurses agree that there's been substandard care, and that negligence has caused a serious permanent injury. And in those types of situations, we investigate the case, and if the case has merit, we'll go forward and file a lawsuit. It's now called a healthcare liability action, and we try to win these cases or settle them, bring them to a resolution that's good for the family and good for the patient, but they are extremely difficult cases, and we only take maybe about 2 or 3 out of every 100 that come to us.
Now, see, that's interesting, because as a reporter, I hear a lot as well. So you're saying it's a very small percentage.
Yes.
That actually rise to the level of being able to go to court.
That's correct.
Why is that?
Because there are a lot of cases where there are what we call bad outcomes. Those are situations where people have had have been injured in medical care or have had failed to heal. And in the vast majority of cases, those are not caused by doctors or caused by nurses. It's just simply the fact the patient didn't get better, because medicine is an art, not a science, believe it or not. Also, there are factors, probably the preeminent factor is juries are extremely conservative, notwithstanding what you hear. And what a lot of us hear in public, they are very conservative in this state, and you have to have almost the perfect case to win at trial, because when you go into one of these trials, the juries favor the doctors and favor the hospitals. There are a variety of reasons for that, but probably most important, everyone has a doctor. Hospitals are well-respected corporate citizens, and so juries they demand a high degree of proof before they will award a verdict for a plaintiff.
How long can it take to get one of these things all the way through?
The range would be somewhere in the neighborhood between 1.5 years to 4 years, and that depends on whether or not the case goes on appeal. It also depends on whether settlement negotiations are fruitful or successful. And in some cases, they're good enough where you can settle it much earlier than other cases. And there's always differences in value where I may think the case is worth more than the hospital or the doctor does, and we will spend sometimes months trying to negotiate to get to a figure that all of us can live with.
And do you hear situations where people have not brought a lawsuit and you think, my goodness, they sure should have looked into this? And what do you think holds people back?
First of all, yes, there are lots of cases where patients have not brought lawsuits where they could. I have doctors and lawyers for doctors tell me about situations where they've been informed that there was a major negligent act, and they're sort of waiting to see if the patient will sue. We'll talk about the statute of limitations in a few minutes, but the reasons why I believe patients don't sue, and the vast majority don't, are they're not comfortable with it. Some don't know any better, believe it or not, Ben. They just don't know what their rights are. And I think many people hope they're going to get better and don't want to resort to the legal system, don't want to go through what they believe to be a difficult, painstaking process, and they sleep on their rights. Yeah. And unfortunately, in some cases where the damages are really bad, they're going to have to take care of themselves. They're no fault of their own.
So you said statute of limitations. That's another good point. So how long can you wait before, maybe a month later you're not sure? How long do you have to make that decision about whether to go through with it?
It is 1 year from the date of the injury or 1 year from the date of the discovery of the injury. And I mean, it's crucial for people to understand that if you don't file suit within that year of discovering your injury, your claim is barred. And I've had many, many times people call me with claims that I thought perhaps had some merit to them, but once I found out that their injury had occurred more than a year after they discovered it and there was no exception to it, I had to tell them the case is time barred. And that is another big reason why patients don't file lawsuits, is they find out that their claim is barred because the lawyer says, I can't take it. You slept on your rights. And the patient's like, well, I didn't know any better. Well, you know, ignorance of the law is no excuse in Tennessee. And so it's very, very important, if you suspect that you've been a victim of medical mistakes, or a patient, or you have a family member who's been a patient, it never hurts to pick up a phone and call. It's free. The consultation's always free.
Is it getting harder? And I mean, we've heard all about healthcare reform and how sometimes these malpractice lawsuits, people look at them and go, oh, that's one of the reasons for rising medical costs. Has it? And so there are all these new restrictions put on. Has it gotten harder to bring one of these kind of lawsuits?
It has, because we passed tort reform in 2008, and then again in 2009, and then again in 2010. The cumulative effect of these measures has made it much more difficult to file one of these lawsuits. It has capped damages for what they call non-economic damages, pain and suffering, loss of enjoyment of life, at $750,000. If you're paralyzed, it's capped at $1 million. But I think the worst part of it is it's poisoned the jury's minds, because they believe these cases are frivolous from the beginning. And when these laws get passed, people think, well, that's just a great thing until it happens to one of them. And then they come to me and they say, why am I capped? Or
right.
Why do I have to go through all this? And, you know, I agree with some of the changes, because every malpractice lawyer, plaintiff lawyer, should have an expert on board before he files a lawsuit. You should never sue a doctor or hospital without having an expert who says this was bad care. That I agree with. But to cap people on their damages, basically for the government to say this is all you can get and take that decision out of the hands of the jury, to me it's just not right. And the fact that these cases now are harder to file and more difficult to pursue means that, like I said earlier, Ben, you can only take maybe 2 or 3 out of every 100 cases, because you just can't afford to lose these cases on a regular basis. You won't be in business much longer.
I bet. We now have a new legislative session is coming up. Are there some proposals this legislative session that would change how medical malpractice is done? Are you aware of anything? Yeah,
what they do every year is they will try to pass a bill. One of them is to try to raise what they call the level of proof necessary to prove negligence in the emergency room, where now you have to prove it by what's called a preponderance of the evidence, which is the greater weight of the evidence. They want to raise it to clear and convincing evidence, which would make basically just about any case in the emergency room not worth pursuing, because there's always going to be a defense of these cases. The second thing, and this is probably the most alarming, I don't think it would pass, but they want to create a health court, which would be an administrative body, kind of like a workers' compensation court, so that they take juries and judges out of this and hire so-called experts, which are just going to be bureaucrats, deciding whether or not a patient has a case or not.
They make it like the workers' comp system.
Correct. And that's the way you take it out of the hands of the people and give it to bureaucrats. And as if we don't have enough government already, they want to create more government to decide these cases. I don't think that's going to pass, because I think there's enough conservative opposition to it, but it's always there. But we're always on the defensive, because we realize that patients don't have the type of political strength in the government that the hospitals and the doctors do.
So what we want to do is basically hear from you. If you have a case, a situation, and you're wondering about it, why don't you give us a call, and Clint Kelly can assess it, tell us what he thinks. But there's the number, 615-737+, 615-737-7587. We'll open up the phone lines, give us a call. We'll take a break right now, but we'll start taking your calls when we come back. We'll be back right after this.